Yes, welcome to the online discussion on the chapter in the Evidence Act regarding examination of witness. You know, from section 135 onwards, there is a chapter, that is chapter 10, which provides of the examination of witness. You know that section 5 of the Evidence Act provides evidence will be given to prove fact in issue and of relevant facts and of no others. So always bear in mind, when an evidence is tendered in court, that evidence must be with relate to fact in issue, or if that evidence comes within the provisions of section from section 6 to 55, that is relevancy chapter. So if that is not coming, then the court will test the evidence on the touchstone of this section 5 and will not allow such evidence. You are also aware of the fact that oral evidence and documentary evidence, that has been defined in the Act. What it provides, that all statements which the court permits or required to be made before it are called oral evidence. Similarly, all documents, electronic records, which the court permits or takes for inspection of the court, those are produced. Those are documentary evidence. So, for the oral evidence is concerned, always a witness is examined in court. Then who is a witness? A witness must be a person who has some personal knowledge about the fact regarding which he is deposing. Section 59 of the Act provides that a person will testify if he has personal knowledge. That is, if some fact can be seen, that must be of it. The person who will be a witness, he must have seen that fact. Or if it is heard, the person must be a person who has heard, or if he has personally perceived by sense, then by the person who has personally perceived that fact in sense. Here's evidence is no evidence, that is section 60. There are two sections. So evidence, when a witness is examined in court, he must have some personal knowledge or a direct knowledge about the fact in issue or relevant facts. If he says that he heard something that is not admissible, then who will decide the admissibility? Always court decides the admissibility of a particular evidence in a particular suit, proceeding, even is a criminal proceeding, any other matter. So section 135 says, the order in which, when a witness is tendered, witness is produced by the party, then in what order, serially, who will a witness is to be examined? Section 135 says, the order in which witnesses are produced and examined, in which witnesses are produced and examined, shall be regulated by the law for the time in force. Suppose it is a civil case, civil suit, then according to civil procedure code, order 18, that how evidence is given, when a witness who will begin the evidence, who will begin the suit first. If no evidence is given, who will lose the case? He will begin the case. So that is the order in which, order means what? Who will be examined first? Which witness will be examined first? Always it is in the, that is the advocate knows in what order he examines the witness. Whether he examines a particular witness first, whether he examines the plaintiff, or that is plaintiff's brother, or any other outsider. In order, that is always the advocate exercise this discretion. but subject to the provision for the timing in force. Section 135 provides the order in which witness is to be examined, that is to be regulated by the procedure code, civil procedure code or the criminal procedure code, which is for the timing in force. Suppose if no law is there, then according to the decision of the courts. So you should understand the provisions of section 135. In what order witnesses are to be examined? What section 135 says? The order in which witnesses are not only examined or produced, witnesses are produced and examined, shall be regulated by the law and practice. What is the practice? Every High Court has a particular practice. In the state of Odisha, we find general rules and circular orders. That is the practice. That is to be order in which the witness is to be examined. That is to be regulated by the law and the practice. Practice for the time being relating to, for the that law and practice for the time being related to civil procedure code or criminal procedure code, respectively. And in the absence of any such law, suppose there is no law, there is no practice, then in absence of any such law, by the discretion of the court. Here court is given discretion. Suppose if in a particular order, a particular witness is to be there is a particular law, or there is a law, civil procedure code provides a particular rule in which witness is to be produced and examined. So court cannot exercise the discretion. But similarly in the criminal procedure code, as you know, when trial takes place in criminal procedure code, what type of procedure is followed? You know, that is warrant case. Warrant case issued on police report, and issued otherwise than police report. Then summons case, sessions case, trial case, then summary procedure case. Those are regulated by the procedure. That is, so far as criminal procedure code prescribes the rule, the provision, how a trial takes place. So, that the accuser never prove his defense first. Always, prosecution proves, prosecution examines the witness. So, whether the complainant is to be examined first, or a seizure witness is to be examined first, or investigating episode, that officer will be examined first. That is no such rule. But prosecution will produce the witness, examine the witness. After the prosecution evidence is closed, then the usual statement of the accused is recorded as per section 313 of the CRPC. Thereafter, the defense evidence is taken and argument judgment, probably on all cases. So, the section 135 informs what it says, that the witness is to be produced in a civil case or in a criminal case, that is to be regulated by the law and practice. Practice, you must bear in mind, practice means a particular rule is there to be adopted by the High Court, that is the practice regulating that proceeding, respectively. If it is a civil case, the law, civil procedure code and the practice. If it is a criminal case, then criminal procedure code and the practice. In that manner, that is to be order and the production. But order means what? First ki habo, second ki habo. That is the order. Production, who will produce the evidence first? You know, burden of proof is there, a person who wants the court to give a judgment in his favor, section 101, he will give, the burden is on him to prove the fact. So that is why section 135 provides that the order in which witness is produced and examined, that is regulated by the law. That is what type of law? Is a civil case, civil procedure code. Is a criminal case, criminal procedure code. Or the practice, and also the practice. What is the practice of the High Court? practice of a particular place in which witness is examined and produced, in that manner that is to be regulated. But if such law is not there, such practice is not there, then in absence of such law, in absence of such practice, that is according to the discretion of the court. This is section 135. Now section 136 is another provision. Just to decide as to admissibility of evidence. Who will decide? Who will decide the admissibility of evidence? Whether the party will decide. Section 136 that it provides. Who will decide? The judge will decide. Then when admissible evidence is admissible, you know, section 5 says evidence may be given only to prove the fact in issue and the facts on the matter, on the relevant facts, as hereinafter declared as relevant within the provisions between 6 to 55. Section 136 says, when either party proposes to give evidence of any fact, there, this is very important. Suppose the prosecution wants to give evidence, or the plaintiff wants to give evidence, or defendant wants to give evidence, either party, or the accused gives an evidence in his defense, then judge may ask, may here is not mandatory. Judge has this duty, may ask the party proposing to give that evidence. Party who proposes to give that, either party proposes to intend to give evidence, that is, proposes to give evidence, judge may ask that party who proposes that to give that evidence. But judge may ask, or in what manner the alleged fact, if the fact which is to be proved through that evidence, through that witness, if proved, would be relevant. It is a very important provision. When a party, normally it is never followed in practice. When either party proposes to give evidence to prove a particular fact, the judge has a power to ask that party as to in what manner, if that fact is proved, is relevant. And the judge shall admit the evidence if he thinks that the facts he proved would be relevant and not otherwise. And not otherwise. It is very important. So what one party proposes to give evidence to prove a particular fact. The judge is given this power to ask that party how, if this fact is proved, how far it is relevant in the case. If he says this is the fact, it is relevant. It is relevant as per the provision of section 5 to prove the fact in issue, or it is coming within the relevancy chapter, then judge will admit. Then if he thinks, judge will think when. Judge thinks that if it is proved that is relevant, then judge will allow that evidence and not otherwise. Go through the wording, see the section. When either party proposes to give evidence, what evidence of fact? Of any fact. Evidence always is given to prove a fact. It is needless to say again, you must have known what is fact. What fact has it been defined? Anything, state of thing, relation of thing, capable of being perceived by senses, or any mental condition of which a person is conscious. That is a fact. That is physical fact and psychological fact. So thus, when one of the party, either party, proposes to give evidence to prove a particular fact, judge may ask that party as to how that fact, if it is proved, is relevant in the case. And the judge shall admit, here judge will not give a decision but shall admit the evidence if he thinks that the fact if it proved would be relevant. When the judge will admit that evidence if the judge thinks if that fact is proved, that is relevant in the case within the provisions, within the purview of Section 5 of the Evidence Act. That is to prove the fact, that is a fact in issue or a relevant fact, and of no otherwise. If the fact proposed to be proved, one of which evidence is admissible only upon the proof of some other fact. Now come to the second part of the second leg of this section. If the fact which is to be proved, that is admissible only on proof of another fact, then such last mentioned fact, that means another fact, if a particular, suppose to say for an example, dying declaration. Dying declaration of a person was tendered in evidence. When it is admissible, if that person is dead, and that any statement given by that person regarding the cause of his death or the circumstances leading to his death, that is admissible as per the provisions of Section 32 clause 1 of this Evidence Act. So suppose a dying declaration is tendered in evidence. So that is admissible only when the declarant, when the person who had given that dying declaration, that is proved that he is dead. So that is admissible first if that person is dead. So if in such case a particular fact, if the fact proposed to be proved, is one on which evidence is admissible, that fact, the evidence is admissible to prove that fact upon proof of some other fact has to be proved. Similarly, not only dying declaration, but also as per the provisions of 32, a person cannot be found incapable of giving evidence. If that is proved, then only this evidence is admissible. Then such last mentioned fact, such fact, this, if that is proved, then that evidence, that fact which must be basing on that, which a particular evidence is admissible, that fact must be proved first before that evidence is given of the fact first mentioned. First mentioned means the fact which is admissible, a particular fact is to be proved only on proof of another, subject to proof of a particular another fact. In such case, the last mentioned fact must be proved before the evidence is taken to prove the first fact. Only if the party undertakes to give proof of such fact. If the party undertakes, so I will give evidence to prove the death of the person, to prove that person is dead or not, is not found. If such an undertaking is given, then that evidence, even without proof of that the fact that person is dead, such an evidence may be tendered, may be admissible. And the court is satisfied with such undertaking. Not only because of undertaking, no, court is satisfied. For an example, that is a certified copy is tendered in evidence. That is admissible when the original is lost. If the party undertakes that I will prove evidence, give evidence to prove the original is lost, let the certified copy be given as evidence. Then the discretion of the court, if such undertaking is given, if the court gives text as undertaking, then such an evidence, such fact may be, evidence may be given to prove such fact. If the relevancy of any one alleged fact depends upon the another alleged fact being passed through. For an example, if the relevancy of one evidence, relevancy of one alleged fact, any fact depends upon upon another alleged fact. Relevancy of one fact depends on the proof of another alleged fact, then being passed through. The judge may in his discretion either permit evidence of the first fact. In such case, the judge may, in his discretion, permit the taking of the evidence, that fact, first fact, evidence on the first fact, the second fact without proving, without asking for the proof of second fact, or require evidence to be given of the second fact, or the judge as a discretion may ask you prove the second fact, because on the proof of second fact, the evidence is admissible on the proof of another fact. So fact before evidence is given of the first fact. It will go through the provisions of section 136. It deals about the admissibility of evidence. Admissibility of evidence. Then who will decide? Ultimately, the power is with the judge. Judge discretionary power with the judge. So when an evidence is tendered by a party, Judge may ask that party, if evidence is given and that fact is proved, how far that is relevant. Then if he is satisfied that that fact is relevant in the case, then the judge may admit that evidence. Suppose if the fact proposed to be proved, that means as per the subsection 1, if the fact proposed to be proved is admissible on proof of some other fact, on proof of some other fact, judge may ask to prove of the subsequent first some other fact, then that fact is to prove. Or if that party gives an undertaking, judge may take evidence on the first fact without proving of the second fact or the some other fact, because though the first fact is to be proved basing on the proof of such or some other fact. Similarly, if the relevance of one alleged fact depends upon the another fact, the relevance of one fact depends on another alleged fact proved, the judge may in his discretion either permit evidence of the first fact, or if the other party, if that party gives an undertaking that he will prove that fact, subsequent fact, or require evidence to, or may require evidence of the second fact before taking evidence of the first fact. There are a number of illustrations in this case. Why illustration is given in a particular section? Because to clarify, to make it more illustrative, will clarify the doubts and make the position very clear. Some illustrations are added to the section. Let us understand the illustrations. A, it is proposed to prove a statement about a relevant fact by a person alleged to be there. It is proposed to be, what is proposed? To prove a statement. Somebody has given statement about a relevant fact. A person who has given a statement regarding a relevant fact, who is dead, then which statement is relevant under section 32? Under section 32, if a person has given any statement who is dead, in that is admissible as per the provision of section 32, then the fact that person is dead must be proved first, proved by the person proposing the statement before evidence is given regarding that statement. Similarly, illustration B says, it is proposed to prove by a copy of the contents of a document said to be lost. That is a certified copy. Similarly, in such case, the fact that the original is lost must be proved by the person proposing to give secondary evidence. A is accused of receiving stolen property knowing it to have been stolen. If there is an accusation against A that he received stolen property knowing the same to be stolen, then it is proposed to prove that he denied the possession of the property. It is proposed to prove that he has denied the possession of that property. The relevance of the denial depends on the identity of the property. First, the property must be identified. Then the relevance of denial that the property is identified first, that is the stolen property. The court may, in its discretion, either require the property to be identified before the denial of the possession is proved. For the property, whether that property is stolen property or not, that is proved, then the denial will be taken. If evidence of denial is taken prior to proof of this, the fact that the property is stolen, so that will cause inconvenience. That will not be proper. So that is why, in such case, court has a discretion. The court may permit the denial of possession to be proved before the property is identified. It is proper to prove a fact A which is said to have been the cause of the issue. There are several intermediate facts B, C and D which must be shown to exist before the fact A can be regarded as the cause or effect of the fact in issue. The court may either permit it to be proved before B, C and D is proved, or may require proof of B, C and D before permitting proof of A. This is sometimes it creates a confusion in your mind regarding this section 136. Even you go through it again and again, still. But you must not forget that section 136 says the main thing is that the court will decide whether a particular evidence is admissible or not. Basing on what? Even if a particular fact is to be proved, depends on the proof of another fact, the court has a discretion to permit that fact to be proved prior to prove of the subsequent fact, second fact. This section is there. So, this is, in nutshell, the provision of section 136. Now, 137 is a provision, examination check, cross-examination, and re-examination. Examination chief. Examination of chief. The person who have this bar practice, they know examination chief, they are familiar with the word examination check, cross-examination, and re-examination. Section 137 of the Evidence Act provides the party who produces a witness, his examination, the examination of that witness by that party is called examination on chief. Suppose X is the plaintiff. He produces Y to give evidence in his support. So who will examine? The court will not examine, but the person who produces that witness, he examines that person first. That is called examination of chief. Always, whenever a witness is produced, comes to the witness box, he takes oath. Under the Indian Oath Act, he first takes oath, thereafter he is examined. Who examines? The person who has brought that witness, he examines that witness. His examination is called examination chief. What is examination chief? Always evidence is taken to prove a fact in issue or relevant fact. I want somebody will give evidence in my favor to prove my position of the suit land. I brought a particular person of my village. He was examined as a witness on my behalf. So I must ask his question. I have the duty. I am required to put question to him, to examine him regarding the case. Usually, the relevancy chapter, that is first an introduction, explanation, introductory in nature, fact introduce, whether you know the case land, suit land, whether you know the plaintiff or the defendant, and what you know about the case, as to who is in possession. This examination is called examination chief. So, in examination chief, leading question will not be asked if objected by the other party. This is. What is leading question? Leading question means in one word, you should remember, leading question means suggesting answer. A person who puts a question to another, he knows that the answer this person will give, whether the answer which he intends, that is called suggesting answer. That is called leading question. Suppose a question is put, is not your name, you are residing in village so and so. You may say yes or no. Whether did you see the incident or not. So here, it may not be a leading question, but you have seen the incident. This is a leading question. You have seen the incident. If he is asked, whether you have seen the incident, so you may say yes or no. So here it is a leading question. Leading question is that suggesting answer. Leading question is always asked in cross-examination. But leading question may be asked to a witness in examination chief when it is not objected by the other side. If it is objected, by the other side, then if court overrules that objection, then a leading question, usually leading question is put to introduce some facts, which are not relevant because introductory in nature. So what section 137 says? 137 says, the examination of a witness by the party who calls him, who has brought that witness, who calls him, shall be examination in chief. Then, the examination of the witness subsequent to examination chief by the adverse party, that is called cross-examination. Why cross-examination is done? Why cross-examination is done? If a witness is examined in court and examination chief is over, if that evidence is taken, then there is every possibility of that is giving a decision on some untruthful testimony of that witness. The purpose of cross-examination is to bring to the notice of the court as to how a particular witness is not believable, as to how what evidence he is giving that is not reliable. So that is why the adverse party is given this right to cross-examine a witness. If a witness has not been cross-examined, that examination chief may be waived. So what it says, the examination of a witness, it always, but in spite of giving opportunity to the adverse party, if the adverse party does not cross-examine, then that witness decline, that evidence in chief will be relied upon. So what section 137 says? The examination of a witness by the party who calls him shall be called his examination chief. The examination of a witness by the adverse party shall be called his cross-examination. The re-examination. The examination of witness subsequent to the cross-examination. Subsequent to the cross-examination by the party who called him shall be called his re-examination. Section 137 defines what is examination chief, what is cross-examination, and what is re-examination. What he says? The examination of witness by a party who has called that witness is called examination chief. The examination of the witness subsequent to examination chief by the adverse party is called cross-examination. Then examination of that witness subsequent to cross-examination by the party who has called him is called re-examination. Third party said, order of examination. In which order the witness is to be examined. That is provided in section 138. What it says? Witness shall be first examined in chief, then of the adverse party so desires cross-examine. So desires means the adverse party may decline the cross-examination. The witness will be examined first in examination chief. If the adverse party so desires that wants, then he may cross-examine. Then if the party calling him so desires, he will re-examine. Then this section 138 says, first examination chief will be done. Then if the adverse party so desires, he will cross-examine. And thereafter, if the party was called that witness, if he so desires, he will re-examine him. The second limit of this section 138 provides the examination and cross-examination must be to relevant facts. Again, it has been questioned, it has been warned that in section 138, examination and cross-examination must be relevant. That is, examination and cross-examination must relevant to fact. But again it has been added that the cross-examination not be confined to the fact of which the witness testifies on his examination in chief. Always, because section 5 has clearly defined, clearly declared that evidence will be given, evidence is admissible to prove the fact issue under the relevant facts. So that is why section 100 of this second layer of this section 138 provides the examination and cross-examination must be of relevant facts, but cross-examination need not be confined to the facts depicted in the examination sheet. Sometimes a mistake is caused, that is by the court, etc., that not permitting a party to cross-examine any fact outside the examination sheet. But it must be a relevant fact. If a particular fact, relevant fact that has not been reported in the examination sheet, even on that fact, cross-examination may be done. Cross-examination is allowed. What it says, examination chief and cross-examination must be a relevant fact, but cross-examination must not be confined to the which the witness testified in his examination sheet. What witness has stated in examination sheet, the cross-examination must not be confined to those matters. But if it is a relevant fact, even cross-examination can be made. So now you should understand, examination and cross-examination must be a relevant fact, must be related to relevant facts and fact issue. But cross-examination must not be confined to the testimony of a witness in examination sheet. Then the re-examination shall be directed. When a re-examination shall be directed? Re-examination shall be directed to explain some matters brought in the cross-examination. Always re-examination is for the limited purpose of explaining certain matters, certain facts brought in the cross-examination. What is case? The re-examination shall be directed to the explanation of the matter. Re-examination shall be directed to the explanation of the matter referred to in cross-examination. And if a new fact, new matter is by permission of the court introduced in re-examination, what it says? Not only to explain the matter brought in cross-examination, then with permission of the court, re-examination can be made to introduce new facts, new matters, new facts. With the permission of the court, new matter is introduced, then the adverse party must be given to further cross-examine on those matters. So what it says, now you are clear, re-examination is to be made, is permitted to explain the matters brought in cross-examination. But new facts may be introduced by re-examining a witness with the permission of the court. If such new facts are introduced, then the adverse party should be given the opportunity, should be permitted to cross-examine the witness on those matters. Now you are clear? What section 130 said? Witness shall be first examined, that is called examination sheet, and thereafter examination sheet, the cross-examination. Always examination sheet and cross-examination must be confined to the relevant facts and fact issue. But cross-examination must not be confined to the matter which has been testified in examination sheet. Any other fact, any other matter which are relevant to the case, even if it is not in the examination sheet, on that matter, on those facts, cross-examination can be made. Then re-examination is permitted to explain the facts which were brought, the evidence brought in the cross-examination. If new facts are introduced in the re-examination, that means the court may permit a party by re-examining a witness to introduce new facts, which are what that must be always a relevant facts and fact. New facts are introduced, Every other party must be given a chance, must be given opportunity to cross-examine on those matters. This is section 130. Now section 139, cross-examination, a person called to produce documents. This is a very important provision. When a witness is called to produce a document, as because a witness is produced a document, will he be cross-examined? The answer is no. So long that witness is, so long the person who is producing that document is not called as a witness, that means he is not examined in court regarding production of that document, he cannot be cross-examined. This is section 139. What section 139 says? 139 says, a person summoned to produce a document. As because a person has been summoned to produce a document, will not be a witness, deemed to be a witness, will not become a witness by the mere fact that he produced that witness, and cannot be cross-examined unless and until he is called as a witness. When he is called as a witness, that means he is examined by the party on which he stands, or on whose request he was directed to produce a document. Section 139 says, a person who has been summoned to produce a document, because he will not become a witness by producing that document. If X has been directed to produce a document, he produces the court. That is, purpose is over. But as he produces a document, he cannot be cross-examined. When will be cross-examined? When he is examined as a witness by the party on whose behalf he is producing a document, he is brought to the witness box and he takes oath and produces the document, then only he may be cross-examined. This is section 139. 140. Witness to character may be cross-examined and re-examined. Sometimes we forget. What is witness to character? Witness to character. A witness to prove the character of a person. What is character? Witness to character. As you know, there is provision in section, probably in section 52, which we know, that is good character and bad character. In civil suit, character is irrelevant. In a criminal case, bad character is irrelevant. When evidence of good character is given, then bad character becomes relevant. Then that is the evidence regarding character. Let us ask the cost of this repetition. I may remind you, that is section 52 says, character where relevant. In civil cases, the fact that the character of any person concerned in such so as to render probable or improbable of any conduct imposed on his irrelevant. So in civil suit, that is the conduct, any evidence regarding the character of party is irrelevant unless, except in the case when that character appears from the fact in issue. That is, issue itself there is an issue that he is a bad character. That is, if somebody, suppose say for a defamation suit, a person sues another for publishing something in a newspaper affecting his character. So whether that character is, that is, true character is there, on that evidence may be given. Section 52, you are aware of the fact. So in the subsequent section, section 53 also says, if in criminal proceeding, the fact that the person accused of period is a good character is relevant. So section 53 provides that the accused is of good character, that is relevant. But when evidence of good character of accused is given, then in reply, evidence may be given to disprove that thing. In criminal proceeding, the fact that the accused person has a bad character is relevant unless evidence has been given that he has a good character. So if a person gives evidence in a criminal case, he is good character, then the bad character that person is. In case it becomes relevant. This section does not apply to case in which the bad character of one person is itself a fact issue, except like previous conviction. That is, the bad character itself is an issue. A previous conviction is relevant as evidence of bad character. You are aware of the fact? What section 140 says? When a witness is examined to prove character of a person, he may be examined and cross-examined. He may be cross-examined and re-examined. So this section 140 says, wherever that is witness to character may be examined and re-examined. Cross-examined, may be cross-examined and re-examined. Examination is always cheap in there. 141 defines what is leading question. Any question suggesting the answer which a person putting it wishes or explains to receive. The person who suggests answer, which that answer the person expects or wishes that you will receive that answer from him, that is called leading question. Is not your name Rama? So in such case, that person may say either yes or no. So that's a leading question. So here, any question suggesting answer by a person who put that question, which he wishes or expects to give such answer from that person, is called leading question. Section 142 says, leading question must not, if objected, will be put in examination sheet. That means when a leading question is put in the examination sheet, other party is not objecting, then that is permissible. What it says, leading question must not, if objected by the adverse party, be asked in examination sheet. This is only in examination sheet. Leading question, if objected by the other party, must not, if objected by the other party, can be put in leading question. Or in re-examination, exemption sheet or re-exemption, except with the permission of the court. Except with the permission of the court. If the question is put to you, can a leading question be put to a witness in examination sheet or re-examination? Answer yes, when no objection, or even objection when court permits. That is section 142. The court shall permit leading question first as to matter which any introductory matter, where court will permit leading question, it is an introductory. If a leading question is, I say you know the accused, that's introductory. So court must permit the putting of leading question if it is introductory, or if it has been sufficiently undisputed, a very undisputed fact. Court will permit the putting of leading question in examination sheet or re-examination. Even if objection, even if with the objection from the other side, when that is introductory, that is undisputed, or which are in its opinion been already sufficiently proved. In three circumstances, the court may permit the putting of leading question to a witness in examination of chief in spite of objection from the other side. When that answer, that leading question is introductory, relating to introductory of certain facts, or undisputed, or it has been sufficiently proved. Section 143 says, leading question may be asked in cross-examination. Leading question may be asked in cross-examination. Section 144 says, evidence as matter in writing. We have already discussed. This is relating to cross-examination. What section 144 says? either in examinationship or in cross-examination. Any witness may be asked, whether it cross-examination or examination, that is not, may be asked. Whilst under this examination, your examination covers both examinationship and cross-examination. Any witness may be asked while under examination whether any contract, grant, or the disposition property as to which giving evidence. A witness while under examination, either examinationship or cross-examination or examination, may be asked whether a contract, grant, or disposition property was reduced into writing and was contained in a document. And if he says that it was, while on examination that witness says, yes, such a contract, grant, or disposition was reduced into writing, then, or if he is able to make any statement as to the contents of any document, the second circumstance. No contract, grant, suppose a witness is able to give a statement regarding the contents of a document, which in the opinion of the court ought to be produced, or that witness is going to give a statement regarding the contents of the document which the court is of opinion that is to be produced, then the adverse party may object to such evidence. Then the adverse party may object such evidence of that witness being until such document is produced. What section 140 says? When adverse party has a right to object the evidence of a person and ask for production of a document regarding which a witness is deposing. Section 144 of the Evidence Act provides while a witness is under examination, whether it is examinationship, etc., the witness may be asked whether a contract, grant, or disposition property was, and if he says yes it was, or if that witness is about to give a statement regarding the contents of the document, then the other party, the adverse party, has a right to object the taking of further in that witness until that document is produced. The fact have been produced, or until the fact have been proved which entitled the party who called the witness to give second evidence. Second, or until the fact is proved that the original has been lost, or until the fact is proved that the party who has brought that witness, who is deposing regarding the contents of the document, or who says that the contract, grant, or disposition property has been reduced to that document, for that he is entitled to give a second evidence. Explanation: a witness may give oral evidence of statement made by other person about the contents of document if such statement are themselves relevant facts. A witness may give oral evidence of statement made by other persons about the contents of a document. Oral evidence regarding the contents of the document is not admissible, as you know. So here, a witness may be allowed to give evidence regarding the statements of a person about the contents of the document if such statements are themselves relevant. If such statements are themselves relevant facts. Illustration will make you clear what it says. The question is whether A assaulted B. She deposed that he heard A say to B, B wrote a letter accusing me of theft and I will be revenged on him. The statement is relevant as showing his motive for the assault and evidence may be given of it, though. So the document is not there, that is, statement is admissible so far as it will prove the assault. But it says, a witness may give oral evidence of statement made by other person about the contents of a document. It has been mentioned. If such statements are themselves relevant. We have covered up to section 144. In the next class, we will also discuss the other provisions regarding examination in check, examination of witness and their cross-examination. Thank you.